September 17, 2024 meeting for the Zoning Board of Appeals for the City of Troy. My name is Mike Bosbrook. I'm the chair of the board, and welcome to all of our guests and visitors here tonight. We're glad you could carve time out of your schedule to be here. We will start tonight with the first item on our agenda, which is the roll call. So, Mr. Evans, if whenever you're ready, if you could call the roll tonight.
Mr. Fox.
Here.
Mr. Green.
Here.
Mr. McCauley.
Here.
Mr. Eisenbacher.
Here.
Mr. Forster.
Here.
Mr. Kenkre.
Here.
Mr. Bossenbrook.
Here. All right, we'll move on to now the reading of our statement of procedure, which is how we will conduct our hearings tonight. So to my immediate left, Mr. Eisenbacher, if you're ready, if you could read for us our statement of procedure.
Okay. The Zoning Board of Appeals is a group of 7 of your neighbors appointed by the Troy City Council to decide on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Applicants must indicate a hardship or practical difficulty with the land that would warrant the granting of the variance. Procedure. The board will hear the items in the order they appear on the approved agenda. When an item is called, the chairman will verify the applicant is present. Then the city administration will summarize the facts of the case. If there are less than a 4 7 members present at a meeting, an applicant may request a postponement or his or her request can be heard by a full board. If there is no request for a postponement, the applicant will then be given an opportunity to address the board to explain the justification for the action requested. After the applicant makes their presentation and answers any questions that the board may have, the chairperson will open the public hearing. Any person wishing to speak on the request should raise their hand and, when recognized by the chairperson, come up to the podium. The speaker should identify themselves with name and address, indicate their relationship to the property in question, for example, next door neighbor, live behind the property, etc., and state whether they are in favor of or against the variance request and give reasons for their opinion. Comments must be directed through the chairperson. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairperson to speak at one time. At the conclusion of public comments, the chairperson will close the public hearing. Once the public hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, deny, or postpone the request. In order for the request to pass, a minimum of 4 votes are needed. If the request is not granted, the applicant has the right to appeal the board's decision to Oakland County Circuit Court.
All right, thank you, Mr. Eisenbacher. Let's go on to item 3, which is approving our meeting minutes from August. Unless there's any discussion on the minutes as printed, is there a motion to approve?
So moved.
Mr. Fox? Second. And seconded by Mr. Green. Unless there's any other discussion, I think we're ready to vote on the minutes, Mr. Evans.
Mr. Bossenbrook.
Yes.
Mr. Green.
Yes.
Mr. Kenkre.
Yes.
Mr. Eisenbacher.
Yes.
Mr. McCauley.
Yes.
Mr. Fox.
Yes.
Mr. Forster.
Yes.
All right, minute meetings have been approved. Now we'll turn to item 4, which is approving tonight's agenda as printed for us. Unless there's any discussion about the agenda as it has been printed out, we will consider it approved. All right, the agenda will be considered approved. And that will take us to the hearing of our cases tonight. We have 1 case in front of us, and that is pertaining to 5356 Capri, if I pronounce that correctly. Mr. Evans is going to kick us off by giving us the city's presentation on the case summary. So, Mr. Evans, whenever you're ready to go.
Thank you, Mr. Chair. As printed in the agenda, this is a variance request to allow an existing deck to be located within a dedicated easement. The deck was constructed without city approval. This is an aerial of the neighborhood. The property is outlined in red. Pretty much in the middle, we've got Coolidge to the west and Long Lake to the south, and I'll keep zooming in. Here's the subject property on the north side of Capri. It's in a single-family residential district. Everything you see in the picture is used and zoned for single-family residential. I'll continue to zoom in. You can get a better idea of what the property looked like when this photo was taken a little more than a year back. Now, the subject matter is the ordinance section 7.03, accessory building structures and uses. This is a deck, and item A3 says accessory structures shall not be located within a dedicated easement. So that's what they're here for relief for tonight. Now, this is a survey of the property. We've got Capri on the bottom, and I've outlined in red the subject area. There's a note here, 6-foot wide easement for public utilities and surface drainage, and that's indicated in this area here. And then they're indicating that there's an area to permit decking to remain within the easement area. So this is to represent the decking. This is a concrete pool deck with a pool. So a portion of this decking is located within that 6-foot easement. And that easement runs from the back property line 6 feet towards the street. And the applicants provided some indicative photos of what the backyard looks like. So here's on the, I think this is the left side if you're facing it. There's the concrete, but there's a better picture of the Trek decking in the backyard. Now, this is the original subdivision plat, and there are lots circled here. So just to give everybody some perspective, and we see this kind of set up all the time in subdivisions existing and new condos. You see a note here, 6-foot private easement for public utilities. There's a couple of arrows, so that's to indicate that there's easements on either side of the property line, and these dashed lines represent the limits of the easements. So if we look to the back of this property here, you see a dashed line with a note indicating 6 feet. So this easement goes back to the original platting of the subdivision. As indicated here, you can see there's easements throughout, really throughout the entire subdivision. And like I said, that's typical of development in Troy. And that'll wrap up the presentation. I'll turn it back over to the board for any questions.
Mr. Fox has a question.
What is the total area of the deck that is currently located within the easement?
Well, I see a note here indicating the figure 967, but I don't know if that's the whole decking. Maybe we should ask the applicant if they can help clarify that.
I saw your hand go up. Mr. Eisenbacher, did you have a question?
Yep. Thank you. So usually we have concerns about setbacks. This one appears to have no concern about setback for the deck. It's just about the easement.
Right.
Okay. And then, do you know what utilities are underneath that area? Is it just city? Because we have a letter from this city, what is it? Public Works.
The Department of Public Works, yes,
Yes.
the director. We don't know if there's, what utilities are there. According to some maps, it appears that there's a storm line running in this area somewhere. Storm GIS. Looking to see if there are any other utilities in that area.
Okay, thank you.
Mr. McCauley.
I'm looking at the one picture, after the picture that shows the cement on the one side. It shows the utility boxes right there. Where is that in location to the back easement?
Well, I don't want to guess, so we can ask the
Okay,
applicant. They
okay.
provided the photo.
So this is, I guess, a similar question for Mr. Eisenbacher, but do we have a copy of the easement? Does it say specifically what type of public utilities have a right of access to it other than the Department of Public Works?
I don't know if there's any other title work that would indicate something other than the subdivision plat.
And I guess this is a question for Mr. Evans and our city attorney. Just to clarify, our variance, if we were to grant a variance, it doesn't give us authority to negate the rights of an easement holder, is that correct?
That's exactly correct. So it's kind of at the risk of the property owner, should they decide to build a deck there, but then subsequently the holder of the easement needs to get into that area. They would have every right to do that, however they needed to do that, including potentially removing that deck if need be. So anything that the board decides tonight would not affect the anyone who holds an easement and any rights that they have to that easement.
Yes, Mr. Forster.
In the property holder's presentation, they say that this is a temporary structure. Is as far as the law is concerned, is it a temporary structure, and is it treated any differently from a permanent structure?
Well, a building permit is going to be required. They have to satisfy the zoning requirements, as you know, because we're here tonight. However the rules apply to this kind of decking is what they're going to have to do.
Mr. Green?
I had a note from Mr. McCauley. If you look on page 18 at the roughly top right of the deck, there's a small circle and an arrow out that says that's the utility area, to answer your question as to where the boxes are located. To the right end of the
Oh,
gray
yep,
strip.
yep, I see it.
Yeah.
Thank you.
Are there any other questions for the city staff? All right, thank you, Mr. Evans, for your presentation. At this point, we will ask the applicant or their representative if you could come up to the podium and introduce yourself and present your case for how you meet the statement of practical difficulty and whatever else you'd like to hear from the board.
Good evening, I'm Shay. I'm the wife of Nuri Oro. We are the property owners of 5356 Capri Drive.
If you could just speak a little closer to the mic, and whoever's going to speak, I'm sure we can pick it up well.
So we built the deck not knowing that it required a permit since it wasn't a permanent structure. And we mainly built it because of the pie-shaped lot that we have, and we have 4 children, all 9 and younger. So it was mainly put in for a safety barrier because the retaining wall that we had to put is a 2-foot drop on that easement. So my girls have fallen a few times because last year we didn't have it built in. We had like a month of the pool once it was done, and they fell. It's really like we only have a foot or 2 from the spa to the end of the easement. So they were falling through, and a friend of ours told us that that would be a great idea. It's not a permanent structure. They can get through it. And like she was saying, if it need be, they needed to come in and take it, we would take full responsibility of repairing anything that would need to be done. But that is one of the main reasons we put it in, was for the safety of our kids. But had we known we needed a permit, we would have absolutely done that. So we apologize in advance for that. But yeah, that is one of the main reasons we did put it in, and because of the irregular shape of our lot, it's really, there's no other space, and we just wanted to make use of whatever space that we had back there. And that's all.
All right, any questions for members of the board? Mr. Eisenbacher?
To make a comment.
Oh, go ahead, sir.
Sorry.
Thank you. If I may add to that, Mike Pizzola, Design and Architecture, 3300 Auburn Road, Auburn Hills, Michigan. Peter Storer, on the application's not available this evening, but I'm Zeppelin, obviously. But if we may, go back to the plan before this, I'd like to maybe answer some questions. First of all, the decking within the easement area is probably about 150 square feet, just based on the measurements. It might be a little bit less. You have a 3-foot easement, and we're taking 3 feet of it, so, and the property line's 50 feet, so that's roughly 150 square feet. In that easement area, north of the property line is storm sewer. And the reason they're having the grade issues is because the drop to that sewer is such to an extent that it's causing an issue within the buildable area where the pool is located. That's the reason why we had to put that, they had to put that wall in, or the retaining wall on the backside, just to raise it up a little bit to try and make it less than the slope that it was when they built when they bought the house. On the north side, on the south side of the property line are utilities such as cable and power, and the boxes are in the right-hand corner right there, or where the utility boxes are. Those were exposed in that one picture. So as it was stated, the deck is not permanent where it's sitting just on the ground with pads basically. So at any time, it can be easily pulled back and access can be given if cable or power needs to access that area back there to lay a new cable or what have you. And the sewer, per the DPW, will likely never be touched because it's north of the property and they have enough room to work on that side, so sewer will never need to access the easement. If we go back, actually zoom out a little bit. So the issue we have is, if you can see, that rectangle represents your standard lot within the R1 zoning district. And if that was their lot, what they have would perfectly fit within their area. But what they have is the pie shape. So this piece right here and this piece right here are now up front, which create a large front yard that's not usable for a pool. So because that small lot in the back, that's essentially their hardship. So we would request that you consider that in allowing them to maintain the deck and remove it if needed, but ultimately for the safety of their children on that back side of that property there, so. Let's see what else was there. Again, it will be removed if needed. And now,
Put in writing too.
what was that?
If we need to remove it, we'll put in writing.
Oh, yeah, the writing, there'll be a
Like if,
hold harmless clause recorded if needed to hold utilities not responsible if anything happens, and they'll be responsible for removing the deck and allowing access immediately if needed, so.
Okay, I think Mr. Eisenbacher was first, unless you want to defer to someone else.
I was second last time. You said it's temporary and it's basically on those concrete piers. It's not concreted into the ground
Right.
or even posted in the ground.
correct.
It's just on top of the ground. So you could lift it up and put it onto the concrete apron of the pool access and then put it back?
Absolutely.
Basically?
And the grade underneath is maintained just with pea gravel, as is below it in the wall portion beyond it. So the continuation of the natural drainage in that area is maintained.
Okay. And so since pools inherently have to be flat because you can't have a pool on an angle,
Yeah.
this is also a problem with the grade of the property, correct? So that slope of the property gave that drop off?
Yes.
Okay, because we can't consider the needs of your children, we have to consider the land. So it's the pie shape and the topography, it appears, that are your primary problems.
Yeah. And the fact that it's there right now.
Well, we can't consider that either, but yes, thank you.
Mr. Fox.
You might not have an exact measurement on you, but how severe was that slope before you guys came in and flattened it all out?
Not steep enough warranting a wall, but it was 2.5 feet, which is less than the needing a fence. So if you step off a 2.5 foot drop as a 3-year-old, you're gonna cause some ankle issues.
As an adult?
Yeah.
Okay, thank you.
Mr. Green.
Just to confirm, the pool was already there, or no?
Before
the deck?
Before the deck, yes.
You installed the pool?
Yes.
Okay. And that slope was at least mostly already there? Okay.
Yeah.
It became very apparent once the pool was installed that how severe it was, and that's where we are today.
Mr. McCauley, did you have a question?
Nope, the same question you had.
Okay.
Mr. Eisenberg.
Yes, Mr. Evans.
I had a question for the applicant. You indicate affixed to the ground, so you're saying it won't be affixed to the ground, or it will? Because I don't know what the building code's going to require, but it wouldn't surprise me if some kind of bolting or other structural attachment to the ground will be required. But perhaps we could talk about that, because it sounds like the board's talking about, well, the impression I get is you just lift it off, but
That's fine.
just lifting it off might require tools. I don't know what it requires.
The contractor's here and can answer any installation issues that may arise.
My name's David Hoskinson. I've known Nori's family.
Sir, can you just, thank
I've
you.
known Nori's family for probably 25 years, 30 years. When they happened to do the pool, they asked me what we could do for the fall off of that. I built the deck itself. You have 8-foot sections of the subframe that sits on 4x4s with plastic, the plastic circles that the 4x4s sit on. Two 2x12s. I have pictures of all this as well. They go in. Then I have a subframe that goes on top. Each one of the sections, the widest part is at 11.5 feet, which is at the northwest end of the property, in that biggest corner there. That's 11.5 feet. You're at 7 feet on the east side before the step down. We built them in 16-foot-long pieces. I have pictures, and they're joined together like this. They all come unscrewed. The decking sits on top. There's no moving of it at all. The reason of the slope, I actually helped put the pea gravel in for erosion with the matting underneath it. And we put that to the fence originally last fall. And then we left it. But when we built that, we put the pads in here. We moved away the pea gravel because it would move. We got down to the clay ground because I removed the tree stumps that were there originally before the pool got built. So it's all dirt there. And as it steps down, you're about 16 to 18 inches at the fence line above it. You're about 8 to 12 inches along the back concrete wall. So the pillars that we built for the subframe come across with 3 4x4s down, and then the 2x12s in here. They were erected upright. We laid a stringer across the top and kept them straight. Then we built each individual framing. The decking all comes off with what we use is a Trex system, and they have the Hydrolocks, and they all sit on each one of the 16-inch centers all the way across. But they come off there. I don't think there's anything that's over 160 square feet per unit that was built there, but the decking on top is 16-foot lengths. And there's only 2 of them going across the back there, I believe 2, and then a short section. We picture framed around the outside edge, as you could see in the pictures.
Yeah, go ahead, Mr. Forster.
Are the pillars affixed to the pads in any way? They're just sitting on top of that?
They sit on top of it. You put one screw in the bottom of them.
So there is a screw that, okay.
Yes, there's one screw that holds it on there, and we had to level the ground where that pad sat. So it sits down. We dug the dirt out to make each one level to come up to it because you have very minimal clearance when it gets to the pool wall. You have very minimal clearance, so we kept the same elevation of the decking to the concrete right there. And we had to dig out where the round, I think they're 12-inch circumference, and we put them on. You buy them at Home Depot, sir. We couldn't use the cement blocks because it would have stuck the deck up too high. You couldn't get a 2x8, 2x10s in there for the subframing.
And you can't bore holes for the utilities underneath.
I'm sorry.
And you can't bore holes for utilities underneath. You can't
Right, yeah. Yep.
I'm
You
sorry.
have three
Make
services that run.
Make sure we're talking to the
We have
microphone.
3 services that run there. You have electric. That's electric is on the east side of Nori's fence in the back northeast corner, and the electric box is there outside of his property. Then you have the old phone lines ped box and a cable ped box. We left a 6x6 area step down there because they can come up with a directional boring if they had to, and they can hit that location every time if there was any services that had to be changed. We knew if it had to be moved, was the reason we made it the way we did, so it could be removed. it'd be some time consuming, maybe a day or two, and we could take and pull the whole deck off. Stack it up, and then we remove all the subframing and be able to sit it right on the deck. We were aware of the services underneath there. I was really scared when I took the tree stumps out that they would be entangled in that system.
So I just have a question, just regarding the sequence of events. So you built it so that you could remove the deck in case utility needed to get into the property. Can you hear me all right?
I can hear you. I'm sure this is probably a question.
Well, I guess.
My hearing aids broke, so I couldn't hear.
Oh, that's okay. I just want to make sure that whoever's going to answer it can hear me.
Yeah.
So I just want to make sure I understand. So you went through this effort to make sure that the deck, the utility, the easement was accessible.
100% accessible.
So was that before or after you found out there was a variance required?
No, we didn't know there was a.
We didn't know there was a variance because we kept everything.
Right. So I guess my question, so you knew there was an easement there, but you didn't know you had to get a variance?
Our pool builders told us as long as it's not a permanent structure, we should be okay. That's why
Okay.
we made it not permanent.
Okay.
So we figured if they needed access to it or anything like that, that's what the understanding we were. Otherwise, we would have requested to have the permit done way beforehand, you know?
Right.
And they were like, it's like, because they told us we can plant trees there, we can, you know, put grass there and stuff, but we weren't going to have grass cutters come in for just like that small area. So that's why we decided to put that instead. And we just assumed that, I mean, we should have looked into it. Like I said, we apologize.
And I guess where in the process are you in getting a permit? Are you waiting for us to grant a variance, or have you already started the permitting process?
We're waiting for you guys.
We were told that we had to wait for the variance.
We were told we had to get the variance before we go through the building process again.
They applied for the permit and were denied because of the need for the variance. That's where we are today. So we're in between. So we'll go back to the building department once,
Yeah.
if you render a favorable decision.
And I guess another question I have is, to the extent you know, what does the easement say in terms of what utilities have access to that strip of property? I know that you said that there's a sewer drain.
Right.
Is the easement specific as to what type of utilities, or do you know whether or not any other utilities could be used for that public easement?
As far as we know, we still also have a foot behind our fence for any accessibility that's still our property line. So that's within the easement as well. So as far as we know, the only utilities were what he had stated, the electric and what else?
The drainage, the cable, and then phone line, that's it. And phone lines these days are not even being used.
I'm pretty sure one of the ones that are in that section we made accessible is not even, like.
And I guess just remind me again, on that photo, where currently is the electric or gas coming in?
To the right. Yeah. I'm pretty sure it's to the right.
Right in the center, right there, there's heat. Yeah, CTV is cable TV. Then there's right in there, yes, there's two pedestals, phone and cable. The electric is the box on the other property right there. EP is right where the red circle is.
That's where the box is. I'm saying, where are the lines? Do you know?
Oh, we don't know. We'd have to have Miss Dig out there and locate those.
Okay. Yeah, Mr. Forrester.
So, if we did grant this and utility came in and did some work and damaged your property, are you willing to be responsible for that damage?
Yes.
Yes, and I'll put it in writing too. So if need be, I'll put it in writing.
Yeah.
Mr. Eisenbacher.
One other question occurred to me. With this deck there, how tall is the fence?
Over it,
Yeah.
a good 5.
Like when we're standing on the deck?
You can go back to the
Probably
picture.
right
The
here.
picture will show
Okay.
it from those
Yeah.
the four slides will show
It's
it.
not very tall. Like
About 4 feet.
it's a 6-foot fence, but when we're on top of our pool deck, it's about right here,
Especially because of that
with the slope.
So we
Okay.
have to raise it up.
Thank
There
you.
you go, the picture on the left-hand side right
It's
there.
over 48 inches.
Is it on?
That's over
Okay.
48 inches.
Mr. McCauley.
I think where Mr. Eisenbacher is going with that, with the fence, is that because with a pool, in-ground pool, you have to have a minimum height of fence around your pool. Does that still maintain that minimum height from the inside?
Yeah,
with that?
it's at least
I don't know what
48
it
inches.
is. I don't know what the height is for
It's
that.
a little over 48 inches.
Okay.
And I think that's what the requirement is. It might even be less, actually, if I'm not
Yeah.
mistaken.
That's where you were going? Okay, I'm just making sure.
All right, any other questions from the board? Okay, thank you, everyone, for
Thank
your
you for your time.
answering our questions. Appreciate it.
Thank you.
And at this point, we will open up the public hearing. And if there is anyone who would like to approach the podium, identify yourself, and whether you're for or against or have any comment in respect to the variance request, be happy to hear from you.
I'll be right here.
Yes, take your time, sir. Appreciate it.
My name is Bob Ustevich. I live next door to the Oros. They're take care of their house very well. Probably, they could have spent less money buying a house in Oakland Township in comparison to what they've done to their house. If the man says he's going to take it out and pay for the repair, he will do that. Since they put the pool in, I was concerned originally because we've had flooding in the past, and since they've had the pool, we haven't seen any water accumulating in the back of our lot. And that was there before they had a pool. So whatever they did something, and there's less water accumulating at the back of the lot, because both of our lots are deep. I mean, they go down. When we bought the house originally and looked at the lot, the land was flat. And when our house was built, our house is probably 6 or 7 feet above the sidewalk. So I can just say they're good neighbors, and I don't think you'd have a problem with them. Okay.
Does any board member have a question for? All right, thank you, sir. Appreciate your time coming up and your comments. Is there any other members of the public who wish to speak? I don't see anyone else coming forward. I don't know, do we have any written correspondence, Mr. Evans?
We do, Mr. Chair. The Department of Public Works has reviewed this and has some thoughts. And you've each got a copy of this at your seat.
Mr. Eisenbacher, do you want to maybe read or summarize that for us?
It's well written. I'll go ahead and read it. It's from Kurt Bovensheep, the Public Works Director. The City of Troy owns and operates various infrastructure assets and utilities which are frequently situated on private property. These assets are accessed under recorded easements that grant the city the right to enter private property for maintenance and repairs. Such easements typically restrict the placement of vegetation, structures, and other objects that could obstruct access to these assets. The property owners at 5356 Capri Drive has requested permission to encroach on a rear yard easement by 4 feet. This easement, originally established at a 6-foot easement for public utilities and surface drainage, is affected by the proposed encroachment. The Department of Public Works has assessed the current position of the storm drain utility and does not oppose the proposed encroachment, provided that the City of Troy will not be held responsible for any damage to the encroaching structure or for its replacement if it needs to be removed for maintenance, repair, or replacement of the storm drain utility.
Okay, thank you, Mr. Eisenbacher. All right, I don't see any other written or other comments from the public, so we will go ahead and close the public hearing, and at this point, return it to the board for our discussion and resolution. Mr. Green, do you want to start us out?
Please. My only concern is the D, the characteristics which make compliance with dimensional requirements difficult must not have been created by the current or a previous owner. Now, very, very clearly the land was platted this way. This property is this way, not because of the homeowner, but because of the city. But the pool and therefore the fence are the result of the homeowner. So I am of two minds on this because I completely understand wanting to ensure the safety, wanting a pool in general, and then deeply appreciate your willingness, understand the misunderstanding, being misled by the construction company. But I wonder about that particular point as far as our requirements. Beyond that, I think it's fairly straightforward. I believe that the rest of the points requirements are clearly met.
All right, thank you, Mr. Green. Now, Mr. Fox?
Well, to that point, I will say that the topography of specifically the slope would not have necessarily been applicant created. So I do understand the thought in terms of the dimensional requirements, but I do think in terms of the slope that led down to the sewer, the easement itself, that to me doesn't feel like something that was applicant created. But again, I'd love to hear the thoughts of the other members of the board.
Yes, Mr. McCauley.
Whether we vote to table this, approve this, or deny this, one of the things that, and they've said that more than once in their presentation, was that they have no problem being responsible for any damage that is incurred on there. If there's a proposal to approve, I would want in that approval the last few lines that Mr. Bovenseep put in his letter, provide that the City of Troy and utilities, I would like to add to that, will not be held responsible for any damage to the encroaching structure or for its replacement if needs be removed for maintenance, repair, or replacement of any storm drain utilities or utilities. So that way, if let's say they have an electrical issue there and they have an electrical line underneath there, they got to go in and tear up that line and they need to have access to it. Well, they should have access to it without having to pay for the damage that they did, because this is a variance to allow them to put it in there. So we're giving them permission to encroach, but the utility should not have to bear the responsibility of the cost, nor the city. So that's my only input at this point in time as far as that's concerned.
I saw a comment from Ms. McMillan.
Yes, if I may add to that, if the board is inclined to grant the variance, I would ask the board consider potentially adding in language about there being a hold harmless agreement as it relates to all utility easement holders, anybody that would have an interest, so not just the city,
Right.
But the other utilities as well. And then, although it is a given, potentially language that acknowledges that the variance would not eliminate nor affect in any way the utility easement and the holder's ability to access and do what they need to do to that utility easement. So something for the board to consider if there is a resolution this evening.
Yes, Mr. Forrester.
I just want to make sure that the rest of the board members know that I agree on the practical difficulty in terms of the shape of the lot and the topography. I think they made the case there.
So I have a question for city staff regarding a hold harmless agreement. Is there one that is typically used for situations like this?
The city, I guess, imagined would draft something that would need to be signed as a condition of the variance that would not only include the city's interest in the property, but any other potential utility holders or utility companies as well.
Yeah, Mr. McCullough.
So what I'm hearing is that this is something we're going to have to draft and put together. So this isn't something that we can do tonight. This might be something we need to postpone with the understanding of having this written, the language included what you were talking about, the hold harmless and everything else, and then if we postpone it, then bring it back next month, then if we're inclined to approve it at that point in time, then we have the language in place for it.
It could be a conditional approval as well on, conditioned on a hold harmless agreement being drafted and signed and agreed to. Any approval could be conditioned on that.
Would that become part of an addendum to our resolution?
So the resolution, it would be ultimately attached
Okay, that's all
and
right.
included, yes.
Okay.
And I agree with what she said as well. I was thinking along those same lines.
Okay.
You make it a condition, the city attorney's office establishes it with them, and then it comes back and gets attached as the condition that was initially authorized to be executed by the board.
Just try and figure out the sequencing if that
Oh,
goes.
for sure.
Yeah, Mr. Fox.
I think, so the language that we use when we're in the planning commission is to the satisfaction of city staff. Either we'll reference the city legal team or we'll reference, city staff. So I think that might be useful here. One other point I wanted to make is, I've worked for a couple of different communities throughout Southeast Michigan, and I will admit, I've never seen like a letter like this, like seeing city staff saying, hey, it's cool if you encroach on the easement. I think that is kind of something that should be highlighted in terms of considering whether or not we grant this, because at least from my personal experience, it's pretty rare. So tells me that there is a exceptional enough circumstance here.
Mr. Green, was your hand up?
Yes, I just wanted to add, as a possible tweak to the language, should we move in this direction of, conditional upon agreement of, et cetera, but to, in addition to adding the hold harmless for utilities and the city for the utility, but also the storm drain is referred to as a utility, but the easement is also for drainage in general, so we'd also need to include that language, although I don't know if we need to include that particular verbiage on our side. But that I actually also, to follow up on Mr. Fox, I also agree. I haven't been on here as long as some, and I haven't worked in multiple cities, but I have only encountered this a couple of times, including at other city council meetings where the city goes, and actually, we're cool with this. So thank you to Mr. Bovensheep for taking the time and being concerned enough to put this together on behalf of, it appears more or less, on behalf of the homeowner, and for taking the time. So thank you to city staff.
So I have another question for city staff. As part of the permitting process, are other utilities notified that an easement that something's being permitted that's encroaching on an easement? Is that part of the process?
I'm not sure if it's any, I know we check our interests within the city, but outside the city, I don't know if that's the case.
Well, if I may.
Yeah.
I believe when you put a fence on an easement, you have that tacit that if something has to happen, you're responsible for removing your fence or fixing the fence as needed, because the easement has precedence over the fence, and it'd be similar to that sort of situation.
Now that you mention it, I recall there is a boilerplate hold harmless agreement that is usually a condition of fence permits that are issued by the city building department. Now, I don't want to over speculate and suggest, but that's to what Mr. Eisenbacher is saying.
Mm-hmm.
I've seen that. I believe they still use that right now.
Okay, well, we had some discussion. We've had a few people indicate maybe leaning in favor, and some discussion about potential language in a motion. So is there anyone who wants to move forward? Mr. Fox?
Yeah, I'll throw a motion out there. This will be a slightly unique one, so.
And I would just say, if we're going to have a motion, and we're talking about precise language, let's make sure we clear what we want to say.
Absolutely. So I'll go through the five, our standard, let's what's the word, exceptional conditions. I'll go over the standard, and then I believe the extraneous circumstances I'm referencing is that a hold harmless agreement is drafted between the applicant and the city. That is a condition of this approval based on the, up to the satisfaction of city staff, something to that extent. Cool. Seeing some nods, so. All right, I would like to motion that the variance request for 5356 Capri Drive for a variance on encroaching on the easement be granted for the following reasons. The applicant has demonstrated that the exceptional characteristics for the property for which the variance sought make compliant with dimensional requirements substantially more difficult than it would be in the case of great majority of properties. So that would be the unusually shaped lot, and then also the topography of the site with the slope going down towards the drainage there. The characteristics which make compliance with dimensional requirements must be related to the premises. They are. It's not related to any of the neighbors. The characteristics which makes compliant shall not be of a personal nature. It's not of a personal nature. The slope is the slope. Characteristics which make compliance with must not have been created by the current or previous owner. The slope was there. It was built on a slope. The proposed variance will not be harmful or alter the essential character of the area in which the property is located. Does not appear as it will. In fact, we've had neighbors come in saying that they support it, so I'd say they check that box. So they meet all 5 of those conditions, plus conditioned on the approval of a hold harmless agreement that is drafted between city staff and the applicant that addresses that the city will not be held responsible for damage to the encroaching structure or utilities will not be held responsible for any damage to the encroaching structure or for its replacement if it needs to be removed for maintenance, repair, or replacement of the storm drain utility or any other utilities present on the easement. Drafted to the satisfaction and approval of the city staff.
All right. Well done. All right, we have a motion. Any second? Mr. McCauley seconds it.
Second.
Okay. Any further discussion from members of the board or city staff? No? Okay, I think we're ready to vote on the motion to grant the variance as set forth by Mr. Fox with the conditions that he has noted. So yes would be to grant and no would be to deny.
Mr. McCauley?
Yes.
Mr. Bostonbrook?
Yes.
Mr. Eisenbacher?
Yes.
Mr. Kenkre?
Yes.
Mr. Fox?
Yes.
Mr. Forster?
Yes.
Mr. Green?
Yes.
Okay, the variance request has been granted with the conditions noted. So thank you for coming out. Appreciate your presentation and answering all of our questions. It was a good discussion, so thank you for everyone that came out. That ends the portion of the agenda with the hearing of the cases, so we will move on to item 6. Do we have any communications, Mr. Evans?
Only that we do have at least one case for our October meeting, so plan on attending that.
Okay. And yes, Mr. Fox.
I will say as a communication, I want to give city staff a big pat on the back for Troy Days this year. I was able to swing by as I was voting in the cutest pet competition for my own cat, which had been entered. And honestly, the event looked fantastic. Looked like very well attended. Everything was set up great. The rides looked super fun. So great job, city staff, for getting that all set and rolling.
All right, thank you. Item number 7, any miscellaneous business? Don't see anything listed.
No.
We will leave anything else open for public comment if there's anyone who wishes to speak on any item. Yep. Ma'am, if you, hold on, wait, if you would like to step forward, we're gonna have to pick everybody up on the microphone. If you just want to identify yourself, and you have the floor.
I live in Chesapeake. And pursuant to the previous conversation, how does that variance carry over to the next owner of that property? I'm just curious. When they sell their house and the next people come in, are they then responsible?
The variance runs with the land,
Okay.
so the future owners could maintain what was approved by the variance.
So it goes with the property.
Yes, with the property. Yes.
They would still be tied to that same hold harmless requirement.
Thank you. Great question. Don't see anyone else coming forward for public comment, so we will move on to Mr. Eisenbacher. Did you have?
No.
Oh,
Just
okay.
only one other.
All right. We are then, I think we've concluded our business for tonight, and so we will adjourn and see everyone in October.